Good afternoon, everyone, and thank you for joining us today. If you could please introduce yourself in the chat, so include your name and pronouns, and if you're with an organization, please add that information as well. It is a pleasure to be here. My name is Jada Hicks. I use she, her pronouns, and I am the senior PJP attorney with the Center for HIV Law and Policy. So in 2025, CHLP is celebrating 20 years of making positive justice possible through legal, advocacy, innovation, and an unwavering commitment to HIV justice. From its inception, CHLP has worked in close partnership with HIV advocates and prioritized addressing the impact of HIV on LGBTQ+ people and Black and Brown communities. CHLP is a multiracial organization that uses a Black feminist queer lens to analyze the issues of discrimination, criminalization, and oppression of people affected by HIV and other stigmatized conditions. HIV criminalization represents a facet of the broader oppression of people living with and deeply affected by HIV, especially Black people, LGBTQ+ folks, working class folks, people who use drugs, and people who engage in sex work. Although our main focus on people living with HIV, we acknowledge that many people living with other conditions, such as hepatitis C and other sexually transmitted infections, are punished with severe criminal and other consequences based on their health status. We envision a world free from state violence, where people are not dehumanized and punished for their real or perceived health status and/or identities, and where health conditions are not met with criminalization, surveillance, and other punitive responses. So the Positive Justice Project, PJP, is a central component of CHLP's work. PJP works with state and local coalitions of people living with HIV, advocates, researchers, nonprofit leaders, government officials, and other stakeholders. Through this work, CHLP supports federal and state advocacy efforts, including mobilizing advocates, organizing and strategizing with coalitions, educating stakeholders and policymakers, and drafting policy and advocacy resources. I will now turn it over to my colleague, Sean.
Good morning, good afternoon, folks. My name is Sean McCormick. I am a staff attorney with PJP at CHLP. I use he, him pronouns. Through our PJP work, we collaborate with partners on a state and local level, including Professor Kara Ingelhart at Northwestern School of Law. Professor Ingelhart joined the Northwestern Pritzker Law faculty in 2024 as the director of the LGBTQI Rights Clinic and a clinical assistant professor of law, where she now leads in clinical instruction and management of the LGBTQI rights advocacy efforts. Her substantive areas of interest include low-income advocacy, criminal legal system reform, and public health law and policy issues that impact the LGBTQI community. Before coming to Northwestern, Professor Ingelhart was an attorney in the Midwest Regional Office of the Lambda Legal Defense and Educational Fund, where she played an instrumental role in advancing the rights of LGBTQ+ people and people living with HIV under federal and state civil rights laws through impact litigation, public policy, and community education. She serves as a commissioner on the American Bar Association's Commission on Sexual Orientation and Gender Identity. I'll pass it over to Kara now.
Thank you so much, Sean, and thank you everyone for being here today. This is our first webinar in this novel clinic with a mission to collaborate with brilliant movement leaders and advocates to expand capacity in the critical work that our advocates outside of the university are doing today. The LGBTQ Rights Clinic serves as an exceptional opportunity for students to get feedback from working with advocates like Jada and Sean on timely matters like HIV criminalization. Our two student presenters today, Kayla and Danny, have thrived in the opportunity to contribute staff attorney type work product in representing clients, conducting pre-litigation research, as well as legal policy research and writing for over at 1.5 semesters, actually nearly 2. Their original clinic work product, practical skill building exercises, and coalition meeting participation qualifies as class credit towards their law school degrees. Kailey Fairchild, who uses she, her pronouns, is in her 3rd year at Northwestern Pritzker School of Law and anticipates graduating this May. She's been a student in the LGBTQ Rights Clinic since the fall of 2024. Last year, Kailey served as president of the LGBTQI+ Allies student group, Outlaw. Kailey holds a bachelor's degree from The Ohio State University and a master's degree from Southern Methodist University, both in the study of art history. Since starting law school, her work has closely investigated the intersection of First Amendment rights and LGBTQI+ rights. Dana Meskan, who uses she, her pronouns as well, is in her 3rd year at Northwestern Pritzker School of Law, but with an anticipated graduation date of the spring of 2006 because she's earning an LLM degree in addition to her JD. She's been a student in the LGBTQI+ Rights Clinic as well since last fall. After graduating from Cornell University in 2001, Dana came to Northwestern to pursue human rights work. She's particularly interested in the protection and advancement of disability rights and LGBTQI+ rights. HIV advocacy falls at the intersection of both. And in this time when it's only becoming more difficult to protect human rights, Dana thinks that working on a state level to decriminalize HIV is one area where she can support making an impact. So today, we will briefly present a history and the basic elements of the Americans with Disabilities Act and how it applies to people living with HIV. We will then explain ongoing discrimination that people living with HIV face today, despite so many advances in HIV medicine and science that should have displaced stigma and fear by now. Then we'll focus on the uses of the ADA to challenge that ongoing discrimination. And on that final piece, I did want to take just a moment and acknowledge how many leaders in the movement who contributed to this work we're presenting here today have registered for this event and may themselves be present. I've not been tracking the introductions carefully. We are so grateful to the academics and scholars who have produced thoughtful theories and strategy on these legal issues, members of the research team from Williams Institute who researched and produced the underlying prosecution and demographic data, and members of the ACLU and TLC litigation team that have put together all these ideas into practice. We're so grateful that you've shown your interest in joining here today. With that, I'll hand it over to the student presenters. Thank you.
Thank you, Kara. So I'm going to start this discussion by describing the history of the ADA. Leading into and through the 1980s, disability rights advocates across the nation advanced the movement for disability legal protections. At the time, the only federal disability discrimination law that existed was the Rehabilitation Act of 1973. But that law, which is still in effect today, only applies to federal employers and specific entities that receive federal funding. Thus, most people living with disabilities were not legally protected from discrimination in employment, schools, or public accommodations like buses or business establishments. In other words, most of what we understand today as basic accessibility needs weren't met. In response to those advocacy efforts, a federal study documented discrimination faced by people with disabilities in all 50 states, and Congress relied on that report when drafting the ADA. After years of advocacy efforts, in 1990, George W. Bush finally signed the ADA into law. The ADA was designed to be broad and encompassing. What that means from an advocacy and lived experience perspective is that instead of taking a narrow view of disability and discrimination, the ADA recognizes that there are many forms discrimination can take and many ways that someone can be disabled. In doing so, it disallows socially driven or misinformed tropes and doesn't emphasize a strict medical view of disability. In other words, the method of the ADA is to dismantle discrimination, whether that's in the form of inaction, intentional animosity, or discriminatory intent. For example, a person who uses a wheelchair may be fully capable of fulfilling a set of job responsibilities and may only be unable to execute them because an employer operates out of an old building that didn't consider the way that some people get around on wheels instead of on their feet. The frame of disability discrimination used in the ADA doesn't assume that a wheelchair user is less able than a person who walks, but takes the view that the problem lies with the workplace having been designed without a wheelchair user in mind. To qualify for protection under the ADA, you must have a disability that falls under one of three categories. It has to be a physical or mental impairment that substantially limits one or more major life activities, or having a record of such an impairment counts, or even just being perceived as having such an impairment counts too. To combat confusion in courts' attempts to narrow the impact of the ADA after it passed, Congress later doubled down and passed the ADA Amendments Act of 2008, which stated directly that the definition of disability should be interpreted broadly. That text provided a wide range of examples of major life activities and major bodily functions. This includes everything from sleeping to working and immune system functioning to reproductive functions. The amendments also made it clear that substantially limits, since the impairment has to substantially limit a major life activity, should also be interpreted broadly in favor of the broad purpose of the ADA as a whole. The quote-unquote regarded as qualifying type of disability was also clearly explained to encompass people without disabilities that impair, so long as the person is perceived or treated as if they have an actual or perceived physical or mental impairment, whether or not that impairment limits or is perceived to limit a major life activity. When determining whether someone has an impairment, assistive devices are not taken into account, with the exception of glasses and contacts. This means that just because you have medication that helps you manage a condition, that does not mean that you are disqualified for protection under the ADA. So for our specific purposes today, people living with well-managed HIV diagnoses and who are undetectable or don't present impairing symptoms of HIV are still protected under the ADA.
In 1998, the Supreme Court held in the case Bragdon v. Abbott that HIV can be a disability under the ADA, even when asymptomatic or when it's being managed. In that case, a person living with HIV was denied services in a dentist's office. The court found that HIV substantially limits the major life activity of reproduction, meaning that it falls under the first kind of the ADA disability definition. Discrimination under the ADA also covers a wide range of actions because disability discrimination can take many forms that can exclude people with disabilities from society. Because of this, prohibited actions can include refusing to provide services, negative employment actions such as firing, transferring, or refusing to hire, failing to provide a reasonable modification or accommodation, or unjustified segregation.
The ADA is separated into 5 different sections called titles. Title I covers employment discrimination. Title II covers state and local governments. Title III covers public accommodations. Title IV covers telecommunications. And Title V covers other miscellaneous provisions. Titles 1, 2, and 3 are the main mechanisms for bringing a discrimination claim, so we'll focus on those sections. Under Title 1, employers cannot discriminate against a quote-unquote qualified employee with a disability during the hiring process, while employed, or during the termination process. Qualified means that the person with the disability would be able to perform the essential functions of the job with or without a reasonable accommodation. Qualified employees are entitled to reasonable accommodations, including things like schedule changes or providing aids, as long as the accommodations are not an undue burden on the business. Under Title II, state and local governments cannot deny a qualified person with a disability access to its programs, services, and activities, or subject them to discrimination. Like under Title I, quote-unquote qualified means that the person would be able to participate with or without reasonable accommodations. Qualified persons are entitled to reasonable modifications of government services, programs, or activities as long as it does not fundamentally alter the nature of the program, service, or activity. It is under Title II that the Supreme Court has established disability protections for people incarcerated in federal or state prisons that receive federal funds, which is most state prisons. Under Title III, private entities that operate a business providing public accommodations must provide full and equal access to and enjoyment of its services to people with disabilities who are customers or clients. Public accommodation is defined very broadly, including everything from hotels to theme parks. Essentially, anywhere open to the public falls under Title III. Businesses must make reasonable modifications to ensure access as long as it is not a fundamental alteration to the service, and they must remove physical barriers as long as doing so is readily achievable by the business. To bring a claim under the ADA, you must establish that you are a person with a disability as defined in the statute and that you were discriminated against because of your disability. In most areas of the country, the disability just needs to be a reason for the discrimination, not the only reason. And this is important. Generally, you want to bring an ADA claim as soon as possible after experiencing discrimination because there is a court-created time limit called a statute of limitations. Since this time limit is not written into the text of the ADA directly, different jurisdictions may have different statutes of limitations. If the discrimination is ongoing, however, the timer for bringing a claim is reset every time there is a new instance of discrimination.
So historically, the federal government has been an ally and an avenue to assist with pursuing ADA claims. In particular, the Department of Justice Civil Rights Division allows you to submit an ADA discrimination claim. They can then investigate and possibly help settle the situation. However, due to one of the executive orders President Trump has put into effect, the DOJ Civil Rights Division is currently on hold from taking on any new litigation. So given this fact and the current administration in general, it's not clear if the Civil Rights Division will pursue ADA claims. But going through the DOJ is optional. It makes the process of litigation easier by possibly avoiding going to court entirely. But if you choose not to file with the DOJ, you would file a complaint to begin a suit. However, if you need to file a complaint for employment discrimination, you must first file with the Equal Employment Opportunity Commission. Regardless of which title your claim of discrimination falls under, the state in which the discrimination occurred likely has a state human rights commission and protective law that would provide a similar process and remedy without the need to go through a federal agency. Illinois, for instance, has a proceeding through the Illinois Human Rights Commission one could pursue, and many people have done so to achieve the relief they need.
So there are approximately 1.2 million people living with HIV in the United States, and they still experience discrimination in various areas of life. To understand this scope, I'll first discuss statistical information about people living with HIV in the US, and then recent examples of such discrimination. Although HIV can affect anyone, in the United States, HIV disproportionately impacts historically marginalized communities, including Black communities, Latinx communities, gay and bisexual men, transgender women, and Black women. Today, Black women are currently experiencing the highest or amongst the highest HIV transmission rates of any demographic group. In the most recent government data, which is from 2022, there were 31,800 estimated new HIV diagnoses in the United States, which was a decrease from 2018. By race or ethnicity, according to the CDC, Black and African American persons made up approximately 12% of the total population of the United States, but accounted for 37% of the estimated new HIV diagnoses. White persons made up 61% of the total population of the United States, but accounted for 24% of new HIV diagnoses, and Hispanic and Latina persons made up 18% of the population of the United States, but accounted for 33% of new HIV diagnoses. Together, Black and African Americans and Hispanic and Latina people made up more than half, 70%, of estimated new HIV diagnoses. By sex at birth, people assigned male at birth accounted for 81% of the estimated new HIV diagnoses, while people assigned female at birth accounted for 19% of new HIV diagnoses. In 2022, as compared to 2016, the annual number of HIV diagnoses among people assigned male at birth decreased 12%, but it remained stable among people assigned female at birth. In 2022, the rate for people assigned male at birth was 4 times the rate for people assigned female at birth. By region, the South accounted for approximately half, 49%, of the estimated new HIV diagnoses. The annual number of diagnoses in the South in 2022 compared to 2018 decreased by 18%. These statistics are important context, but they do not capture the reality faced by people living with HIV, as HIV is highly stigmatized. HIV stigma is negative attitudes and beliefs about people living with HIV, and this can lead to discrimination and affect the health and well-being of people living with HIV. HIV stigma can also discourage people from getting tested, sharing their status, and accessing HIV services. We still see discrimination caused by HIV stigma in various areas of life. For example, in October 2017, Nico Brito-Ramos was denied service by the owner of a Los Angeles barbershop, specifically because of Brito-Ramos's HIV status. Lambda Legal brought an ADA claim in a federal lawsuit. Having gotten a haircut at the business several times before October 2017 without incident, Nico was surprised when the circumstances changed after another barber in the shop, who knew Nico previously, shared his HIV status with the owner. In a clear strike against intentional discrimination against people living with HIV, the case ultimately ended in a winning court decision for Brito-Ramos. Nico's experience highlighted how Black people living with HIV are confronted with discrimination every day, but the judgment also put businesses on notice that such discrimination will not be tolerated. People living with HIV also face barriers to military service. I don't know about you, I just find it exceptionally illogical that our government would ever turn away willing and able volunteers from military service just based on their status as a minority. Despite this, in 2018, President Trump started discharging HIV-positive service members based on their inability to deploy due to Clinton-era policies. In that same year, 2 different lawsuits were filed on behalf of active duty service members living with HIV, Harrison v. Austin and Roe v. Austin. They challenged the military's policy not to commission or deploy service members living with HIV. Essentially, since the onset of the HIV epidemic, the military wasn't kicking you out if you acquired HIV during your military career, but it also wasn't willing to invest any more resources into you to retain you at that point. The lawsuits claimed that the military policies violated the Equal Protection Clause by treating people living with HIV differently than similarly situated peers, and violated the Administrative Procedure Act by being arbitrary and capricious, or in other words, irrational and unpredictable. And ultimately, the cases were successful and stopped the military from discriminating against the plaintiffs and other service members living with HIV. A federal court found that military policies that treat healthy people living with HIV differently from other healthy people are irrational under the US Constitution and the Administrative Procedure Act because they were outdated and unsupportable with today's science and medicine. And more recently, a third lawsuit challenging enlistment bans on people living with HIV, called Wilkins v. Hegseth, was won in a trial court and is on appeal. So this is an important space to watch. Regarding healthcare, in a case at the Supreme Court this term, Kennedy v. Braidwood Management Incorporated, the issue of no-cost access to pre-exposure prophylaxis, which is also known as PrEP, which is used for HIV prevention, and other critical preventative healthcare services, is being argued. The lower court ruling being appealed is rooted in stigma towards the LGBTQ+ community and people vulnerable to HIV. At its core, this case is about more than just PrEP. It's a direct attack on the foundation of preventative healthcare in the United States and a key pillar of the Affordable Care Act. The preventative services mandate ensures that millions of Americans have access to critical screenings, vaccines, and treatments without financial barriers, dramatically improving public health outcomes. So you should watch this space as well. While there are many other areas of life where people living with HIV face discrimination, the last example I will discuss is in the context of incarceration. In 2015, advocates filed a lawsuit on behalf of John Dorn as a result of Dorn being disciplined far more severely than another prisoner based solely on his HIV status under a Michigan Department of Corrections policy. After Dorn and another man were accused of engaging in consensual sexual activity, Dorn was immediately taken from the lowest level security facility to the highest and placed in solitary confinement for over 21 months, whereas the HIV negative person was given only a 30-day loss of privileges. The lawsuit claimed that this unequal treatment violated both the ADA and Section 504 of the Rehabilitation Act. The case ultimately resulted in a settlement with the Michigan Department of Corrections, including substantive changes to the Michigan Department of Corrections policy that allowed such disproportionate punishment of incarcerated people living with HIV without adequate justification.
So as Dana mentioned, the ADA provides a number of avenues to address discrimination based on disability. Recently, the ADA has successfully been used to combat HIV criminalization. I'm going to quickly introduce what HIV criminalization is and how it is enforced before heading into the legal theory behind using the ADA to challenge these laws, and then how groups like CHLP have been successful in leveraging the ADA's protections against state HIV criminalization laws. HIV criminalization refers to laws, policies, and practices that result in increased criminal penalties for people living with HIV for conduct that is either not criminalized or less severely punished for people not living with HIV. These increased penalties can manifest in a few different ways, including distinct criminal offenses that criminalize HIV exposure and transmission. HIV crim also occurs through general criminal laws, such as aggravated assault, that do not specifically mention HIV or another communicable disease, but have been used to prosecute, like quote unquote exposure or transmission of HIV under general definitions of assault. Another common increased criminal penalty is through felony enhancements for people living with HIV, which increase the length of incarcerations or fines. Penalties can come in the form of forced testing or treatment, and some states have particularly severe penalties, such as registration on the sex offender registry and compliance with complicated restrictions. As of the date of this program, 28 states criminalize conduct that is not otherwise criminalized for people not living with an HIV diagnosis. Until this legislative session, that number was 29, but North Dakota passed HB 1217 to repeal the law that criminalizes the willful transfer of bodily fluid containing the HIV virus, which was signed into law on March 31st, and advocates await Governor Wes Moore of Maryland to sign into law the HIV decrim bill that passed both legislative chambers this session as well. We call these laws exposure or transmission offenses that are HIV specific. When we use the term HIV specific, we're talking about statutes that not only identify living with HIV as a criminalized status right into the law, but also statutes that describe communicable, contagious, infectious, sexually transmitted, and venereal diseases. These statutes single out people living with HIV, albeit less directly, for heightened criminal punishments. In using a broader term like communicable diseases, the offenses also add to the oppression and stigmatization of people living with other conditions, such as syphilis, viral hepatitis, among others. Often these offenses specifically name and criminalize commonplace behaviors like having sex or donating blood, but some also broadly criminalize under the route, again, of exposure or something similar. Those states that continue to criminalize HIV impose harsher criminal penalties on people living with HIV due to their positive HIV status than those prosecuted for the same crime who are HIV negative. So, for example, 10 states have syringe sharing enhancements. In general, syringe sharing is either not criminalized or punished less severely under a state's drug paraphernalia laws. But for people living with HIV, they faced increased punishment, often felony punishment, for sharing syringes. There are also 5 states that may require registration on the sex offender registry for an HIV criminalization conviction. So, what do these laws require? For most HIV criminal laws, transmission is not required, nor is proof that the person intended to transmit HIV or that transmission was even likely. All that is required to be proven is that an HIV positive person participated in some kind of activity viewed as sex without first disclosing they are HIV positive to their partner. Allegations of non-disclosure are enough for prosecution under a statute that criminalizes exposure or uses similar language. The proof of disclosure is often the only defense, but as you can imagine, it's usually very difficult to prove. Risk reduction measures or proof that transmission was unlikely to occur typically have no impact either. So, for example, people living with HIV whose viral load is undetectable and therefore untransmittable, those who participate in sexual contact that poses no risk of transmission, or that otherwise use a condom cannot mitigate their punishment with these kinds of defenses, because all that's being criminalized is the exposure to HIV, not the intent or even the likeliness of transmission. These laws often impose severe and disproportionate punishment. Felony level punishment is common, even where no harm occurred, where without an HIV factor, you'd be looking at a misdemeanor. So in other words, a lower level offense with far less punishment. To be clear, not all HIV statutes require so little, but many do. Just as another example, Iowa's HIV exposure statute does require proof of intent to transmit in order to prosecute. So that intent cannot be proven simply with a person's knowledge of their HIV status. And in Iowa, if a person living with HIV takes practical measures to prevent transmission or discloses their status to a partner and offers to take such protective measures, then they have not acted with the intent required for prosecution. It's important to highlight that Iowa's HIV exposure law was updated to reflect a more modern understanding of HIV transmission about 10 years ago after HIV advocates got involved in a post-conviction case and legislative advocacy. To summarize, HIV criminalization is a product of inaccurate, stigmatized views based in queerphobia, white supremacy, and misogyny. These laws emerge from and perpetuate these prejudiced, ignorant ideals. We know from the Williams Institute data that HIV criminalization targets Black people, Latinx folks, LGBTQ+ folks, and women. It especially affects people with intersecting marginalized identities, such as transgender and cisgender, Black women engaging in sex work, Black queer people, and Black people who use drugs. So one of the most common and severe criminal penalty enhancements for people living with HIV are those attached to sex work. In addition to facing the threat of prosecution under HIV exposure offenses and general criminal laws, people living with HIV and engaging in sex work may also face felony level punishment, which could result in thousands of dollars in fines, up to 10 years imprisonment, and significant consequences that extend beyond incarceration. Many of these laws operate simply. After someone is arrested for sex work, law enforcement may discover their positive status through voluntary or involuntary means and up the charge from misdemeanor level prostitution to felony level aggravated prostitution or something similar. Across jurisdictions, women are disproportionately represented among people arrested and prosecuted for HIV-related sex work enhancements. These laws particularly burden Black women, including cisgender and transgender women, and low-income women. Enhancements for sex work often only require that the prosecutor prove that the person was living with HIV, knew of their status, and engaged in an act of prostitution. A quote-unquote act of prostitution can mean a wide range of activities or actions, including loitering to solicit, soliciting, and then, of course, engaging in sex work. Many of these laws impose these disparate penalties on people living with HIV, despite the person not even engaging in physical contact with another person. For example, people may be policed or prosecuted for sex work for possessing condoms, for existing in an area where sex work commonly happens, and for driving by an area where sex work happens. Therefore, there are many situations where people living with HIV will be criminalized with the felony level punishment without ever transmitting HIV, without ever intending to transmit HIV, or engaging in conduct that could even transmit HIV. Since many acts criminalized as prostitution include things like loitering to solicit and soliciting, these HIV sex work enhancement laws are prosecuted in a way where people are caught up in the system without there ever having been an HIV transmission or sex act. 10 states have enhancements for people living with HIV and engaging in sex work. Guam also has a sex work enhancement. Most are concentrated in the South, but there are also enhancements in Pennsylvania and Ohio, as well as in Utah.
To be clear, there is no evidence that these laws improve public health. That is, there is no evidence that these laws curb behaviors more likely to result in transmission, promote disclosure, or reduce the number of diagnoses. However, there is broad and growing evidence that these laws harm our communities. These laws exacerbate stigma against HIV and people living with HIV. And HIV stigma remains a destructive factor for people living with HIV. It also further marginalizes people from HIV services. And the laws worsen the barriers to HIV prevention, testing, and treatment services. For example, many of these laws only apply to people who are aware of their status. This is a clear disincentive to getting tested and becoming aware of one's status. New research from the CDC supports this. It found an association between HIV criminalization laws and decreased engagement in HIV testing. And the opposite is true too. Research shows reforms to HIV criminal laws are associated with improved HIV testing engagement. These laws also perpetuate one-sided messaging about sexual health and prevention responsibility. It shouldn't solely be the responsibility of people living with HIV to talk about HIV and other STIs. These should be open communications between consenting people. These laws also disproportionately harm historically marginalized populations, including people of color, LGBTQ+ communities, sex workers, people who use drugs, and undocumented immigrants. In our work with CHLP, we emphasize these disparate impacts and center the communities made most vulnerable to criminalization. Understanding that these laws subject people living with HIV to differential treatment regardless of their actual conduct, CHLP and others developed a novel approach to use the ADA. The group in charge of this strategy is called Team ADA to Attack Criminalization, or Team ATAC. And our Northwestern LGBTQI Rights Clinic has now joined them in collaboration. In 2018, CHLP assembled a group of advocates, academics, community leaders, and people with lived experience to develop the theory, which would provide a promising new avenue for advocates to challenge HIV criminalization. As I explained earlier, the ADA protects people living with disabilities, which an HIV diagnosis is, from discrimination, and ensures full access to public benefits, including public accommodations like hotels and restaurants. It also applies to public entities such as state and local governments and the agencies and offices that they run.
So, how can we use the ADA to challenge these laws? As Dana mentioned, Title II of the ADA provides redress for those denied access to a program, service, or activity of a state or local government and were denied that program or service because of their disability. Generally speaking, Title II of the ADA protects people living with disabilities from institutional discrimination and ensures equal access to public services. The state agencies that enforce HIV crim laws, including the police, state prosecutors, jails, and prisons, in effect discriminate against people living with HIV, a protected condition, by subjecting them to heightened criminal penalties solely because of their HIV status. By enforcing HIV criminalization, these state actors subject people living with HIV to discrimination because of their disability. So the first time this theory using the ADA to challenge state HIV crim laws was deployed in Out Memphis v. Lee, which challenged Tennessee's prosecution of their aggravated prostitution offense. To see how the ATAC theory was used successfully, I'm going to first outline Tennessee's sex work offense and the HIV-specific penalty enhancement, and then we'll get to the work CHLP did to get this litigation started and how the case is moving now. Tennessee generally criminalizes sex work with a misdemeanor punishment. Prostitution is defined broadly, which you can see here. Prostitution means engaging in or offering to engage in sexual activity as a business or being an inmate in a house of prostitution or loitering in a public place for the purpose of being hired to engage in sexual activity. For aggravated prostitution, the only difference is knowledge of one's positive HIV status. In other words, the only difference is that the person is living with HIV and aware of their status. And with that knowledge, the person can be charged and convicted of a felony. That means that they are subject to the imprisonment for 3 to 15 years and face a fine of up to $10,000. By contrast, people convicted of prostitution can be sentenced to a misdemeanor, which could include up to 6 months imprisonment and up to a $500 fine. And under the law prior to the lawsuit, people convicted of aggravated prostitution were considered, quote, violent sexual offenders and required to register on the sex offender registry for life. We know that people convicted of any criminal offense face intense, severe barriers in accessing employment, housing, education, and other services. But for people convicted of aggravated prostitution, they had even more restrictions on where they could live, who they could spend time with, where they were employed, and more because of their registration on the sex offender registry. We know from a report by the Williams Institute that the enforcement of the aggravated prostitution offense disproportionately fell on Black women in Tennessee. Prosecutions for aggravated prostitution were concentrated in Shelby County, a majority Black county, in which Memphis is located. In Shelby County, 90% of the people arrested were Black, and about 75% of the people arrested were Black women. Statewide, Black women represented about 60% of the people on the registry for an aggravated prostitution conviction. The report also showed that the vast majority of those prosecutions resulted from sting operations, mainly from the Memphis Police Department. More than 20,000 people are living with HIV in Tennessee, with about 800 new diagnoses every year, one of the highest rates of HIV diagnoses compared to the rest of the country, with Memphis being disproportionately impacted by HIV. Tennessee has several criminal laws that target people living with HIV as well. Before the recent efforts, these laws had not been challenged in federal court. State officials have been openly opposed to HIV prevention and treatment efforts, especially efforts concentrated on outreaching to Black LGBTQ+ Tennesseans. The governor very publicly rejected more than $10 million in prevention funds from the CDC for HIV prevention services that historically constituted funding for groups like Planned Parenthood, which had been getting some of the CDC money for condom distribution. In an effort explicitly stated to be a means for the state of Tennessee to exercise control over the final organizations to which funding would go, he alleged that new replacement funds from state coffers would be dedicated towards preventing HIV to be distributed among victims of human trafficking, women, and children, instead of the Tennessee-based orgs that had previously received federal monies, despite any evidence to point to these groups being the most in need of HIV prevention services. Political conservatives, Republicans, who generally oppose HIV criminalization reform, have controlled the state legislature and governorship for over a decade. Republicans have had a supermajority in each chamber for over a decade now as well. In January of 2022, CHLP worked with people directly impacted by HIV criminalization and filed complaints to further Team ATAC's work. These complaints broadly challenged all HIV crim laws, Tennessee as violative of the ADA. Later, in October of 2023, advocates in Tennessee, partnering with ACLU of Tennessee, ACLU National, and the Transgender Law Center, filed a complaint in federal court specifically challenging one part of the law, criminalization of HIV through the aggravated prostitution offense. On December 1st, 2023, based on the complaints, the U.S. Department of Justice then issued a findings letter concluding the state of Tennessee violated the ADA through its enforcement of the aggravated prostitution offense. The letter concluded, and I'm quoting, "The state subjects people living with HIV to harsher criminal penalties solely because of their HIV status in violation of Title II of the ADA. By enforcing this law, the state discriminates against people living with HIV on the basis of their disability," end quote. In the spring of 2024, after inaction by the state, the DOJ then filed a lawsuit against the state to enforce the ADA. The plaintiffs in the suit are an LGBTQ+ organization out Memphis, who have members impacted by the law, along with 4 cis and trans women who were convicted under the enhancement. They sued Tennessee under Title II of the ADA. They argue that both the aggravated prostitution crime and the sex registry requirement are illegal under Title II of the ADA. Title II applies because as people with HIV, the plaintiffs are individuals with a disability, and Title II is the section of the ADA that applies to state governments or their entities like police and prisons. And that suit is still ongoing, but has settled on some of the claims. In May of 2024, the DOJ reached a historic agreement with the Shelby County District Attorney's Office to end enforcement of the aggravated prostitution offense and registration requirements for people convicted. And in July of 2024, the state of Tennessee and ACLU of Tennessee, and the Transgender Law Center reached a partial agreement regarding registration removal. The DOJ settlement is historic. It marks the first time the DOJ has entered into an agreement with a public entity regarding its enforcement of criminal laws targeting people living with HIV. It is also the first time the ADA has been used successfully to counter HIV crim laws. Tennessee must take other steps as part of the settlement, like notifying individuals of their eligibility for expunging parts of related criminal sentences. The Shelby County DA's office is required to make a few important changes to their policies, practices, and procedures, including training their attorneys on these issues. One of the settlement improvements also means that going forward, Tennessee will conduct an individualized assessment of risk of transmission in HIV-related offenses. In July, the agreement in the ACLU suit resulted in a partial resolution of the suit's claims related to registration on the sex offender registry. At the same time, and as a result of the outside pressure from the lawsuit, CHLP and other advocates changed the law through legislation too. That change in the law repealed the registry requirement for people convicted of aggravated prostitution, but the lawsuit settlement agreement requires more than the law alone. The state has to take some steps to help people already on the registry. The state has to compile a list of people potentially eligible for removal from the registry, to alert these individuals of the petition process and provide information on a simplified removal process, and also to notify other state agencies that the person is no longer a registered offender. This case is currently ongoing, so we are closely watching this space to see if this litigation strategy fully succeeds. I want to emphasize that there are inherent limitations to litigation settlements, and that litigation is only one part of this work. The success of the litigation provides case law precedent, it provides an immeasurable amount of credibility for Team ATAC's theory, and it of course provides leverage against future enforcement throughout the state. But nonetheless, the settlement does not provide complete protection against HIV criminalization. The strongest level of protection is when it is written into the law, or conversely, the laws criminalizing HIV are repealed. Successful litigation like Out Memphis v. Lee is a direct consequence of CHLP's legislative efforts and their initial research into states' HIV crim laws.
As Out Memphis exemplifies, various legal and policy organizations are working to protect the rights of people living with HIV through research and involvement in decriminalization efforts across the U.S. For another example, CHLP is currently partnering with us at Northwestern to research HIV criminalization in various states across the U.S. and looking into factors that may affect decriminalization advocacy in those states. This work reviews laws that criminalize HIV, cases about HIV protections or disability rights, state law protections, key political players and their policies, and organizations relevant to an HIV decriminalization advocacy network. We are currently working on memos for Oklahoma and Pennsylvania to help guide CHLP in supporting the coalitions in those states. For like a very general summary, Oklahoma is generally less friendly to progressive policies than Pennsylvania, which is a more politically divided state. Legal and policy organizations can also work to protect the rights of people living with HIV through direct litigation and amicus support. Litigation can be brought either by or on behalf of people living with HIV. People who have been convicted under HIV criminalization laws can sue. For example, in the Out Memphis v. Lee case that we just discussed, 4 cisgender and transgender women, as well as an LGBTQ+ organization with impacted members, sued the state because they were forced to register due to their sex work convictions that were enhanced to a felony because they are living with HIV. To bring such litigation, there needs to be someone who is harmed by the HIV criminalization laws. This may mean a sex worker, as in the Out Memphis case, and it is someone living with HIV. The best way to establish harm is if someone is being charged with one of the crimes, or if they are continually impacted by a criminal conviction. So in the Out Memphis case, the plaintiffs were required to register as a violent sex offender for the rest of their lives. Groups can also bring claims on behalf of their members if the members are directly impacted and the claim is related to the purpose of the group. So in the Out Memphis case, Out Memphis is an LGBTQ+ community and advocacy organization whose members are impacted by the HIV sex work penalty enhancement. This kind of litigation should be brought under Title II of the ADA because it is challenging state law and the actions of state government officials. Enforcement of state law is an activity of the state government, after all. For these claims, one can argue that the criminal statute, penalty enhancement, or registry requirement is discriminatory, and it would not have occurred but for a person's HIV status. There may also be avenues outside of litigation or during the litigation process to prevent HIV criminalization laws from causing harm. Prosecutors do not have to pursue a case against someone who has been charged with a crime. This is known as prosecutorial discretion. This means that even if a criminal law is not taken off the books, a settlement or agreement could be reached with the state to not prosecute cases under that law. Prosecutors may agree to such an arrangement to avoid litigation and discrimination claims. The challenge to the Tennessee sex work penalty enhancement in the Out Memphis case resulted in such settlement arrangements as discussed by Kailey earlier. Individuals can also bring an ADA claim directly. As mentioned previously, generally, you want to bring an ADA claim as soon as possible after experiencing discrimination because there is a court-created time limit. Your claim must fall under one of the titles of the ADA, and each requires something slightly different. I'll discuss the three most frequently used sections by far, Titles 1, 2, and 3. For Title I employment claims, you first must file a complaint with the Equal Employment Opportunity Commission, which is a federal agency. If the Equal Employment Opportunity Commission provides a right to sue letter, then you can bring a claim to court. And in court, you have to establish that you are a qualified person with a disability, you experienced a negative employment action, and the negative action was taken because of your disability. For Title II claims against state or local governments, which is common in prison discrimination cases, you do not need to file first with an agency, and instead you may either file a complaint with the U.S. Department of Justice or file a complaint directly in federal court against the discriminating entity. In either venue, you must establish that you are a qualified person with a disability, you were denied access to a program, service, or activity of a state or local government, or you were subjected to discrimination by a state or local government, and that the denial or discrimination was because of your disability. As of the date of this program, the U.S. Department of Justice website for filing an ADA complaint with the Civil Rights Division remains available online. It includes a short online form where you can submit information about your claim. You can also print out the form and mail it in. Submissions must be made within 180 days of the instance of discrimination. Review from the DOJ can normally take up to 3 months, but it may also take longer or not be done at all. The DOJ is not required to take any formal action after receiving a complaint. But if they do, they may bring the parties to a mediation process. If the issue is still not resolved, the DOJ may then bring a lawsuit. For Title III claims against public accommodations, which again has been broadly defined, you are also not required to go through an agency process, and you can file a complaint with the DOJ or file a complaint in federal court against the discriminating entity. In either case, you must establish that you are a customer or client with a disability, that you are denied full and equal enjoyment of the services of a provider, and that the denial was because of your disability. Filing a complaint is not the only thing you can do, though. If you did want to be involved in fighting HIV criminalization, you as an individual impacted by HIV or as an advocate for HIV-related issues can join a coalition in your state. Members in coalitions can support organizing and education of voters and elected officials. To learn more, you can reach out to CHLP or the Sero Project, who are plugged into HIV coalitions across the country.
As we mentioned, Dana and I, through the clinic, are involved with the wonderful advocates in Pennsylvania and Oklahoma in their coalitions, and would recommend plugging into your own state. And with that, thank you so much for joining us today. We'll now open the floor for questions, and our facilitators will rejoin us on stage.
Thank you, Kailey and Dana. That was wonderful. So much useful information. We do actually have one question already that came in while you were presenting from Deborah Eastman, asking how would someone know, how do they know whether you have HIV if you don't tell them?
Like when you're being prosecuted with a crime,
I think
I assume.
maybe asking about reasonable accommodations and maybe how, I think it came in during that portion, whether how they would know whether or not you have HIV if you don't tell them.
So for the reasonable accommodations process under the ADA, you do, as a person with a disability, you do have to tell someone, you have to ask for the reasonable accommodations. There are some limits on like the amount of information that whoever you're requesting the accommodations from can require from you. Like they can't ask for all of your medical information and things like that, but they are allowed to know certain things. You do, to get accommodations, you do have to disclose that you have a disability and what accommodations you need, essentially. So that does require some form of disclosure.
Thank you, Dana. I see that we have another question from Todd. And hi, Todd. I hope you're doing well. This question is about different types of laws that we might challenge using the team attack theory. How would you approach a lawsuit for the battery type laws and things like spitting, where there is a felony enhancement for people living with HIV? How would a lawsuit work? What would be needed? We have data now from Williams Institute that shows people living with HIV receive harsher punishments under our battery and bodily fluid law here in Indiana, for example. Could we claim that discrimination under the ADA now that we have this research data, or do we need a qualified person? Y'all are welcome to take that question. I'll also open it up to Jada, perhaps if she has some insights to add.
Yeah, I was just going to say this is actually something that Sean and I at CHLP have discussed researching and figuring out how we can bring and utilize ADA claims in other settings outside of a sex worker enhancement. And so right now, as part of partnering with Northwestern, like we're going to be exploring research options and what we can do. So please stay tuned. We don't have necessarily the background information yet to bring a lawsuit. So usually we gather information on like what has happened in the state, what ADA protections may be in the state law, look at what the language of the specific statute is, look at the legislative makeup, identify legislators that may be helpful to our cause. So there's a lot of background work that needs to be done. So we're going to be doing that research and then drafting memos and seeing how we can utilize the ADA with some different criminalization statutes that affect people living with HIV and other stigmatized health conditions. I don't know if Sean, if you have anything else to add. That's just kind of where I see it, is like this is an emerging issue. We're responding in the moment. Given where we are with this administration, now is really the time for us to do the research and build this up so that we can bring a case when appropriate.
Exactly, Jada. I would just second that. It's very dependent on the statute, but we're also doing research on the political and social context that will prepare us for additional complaints and litigation potentially.
And I just want to share that Nathan from the Williams Institute is sharing that we have arrest reports in Indiana, so we know exactly what happened thanks to our state partners. So there's definitely some work that needs to be done, but we are exploring those options, Todd. I'm thankful that you have brought that question to the forefront and that there are other people that are thinking of ways that we can really utilize the ADA.
I would assume that, well, it depends very much on the wording of the statute, that it would still be a Title II claim in a similar way that the sex work enhancement challenge happened in Tennessee for other similar laws.
Please feel free to add any additional questions or comments that y'all have within the chat. We're happy to answer them. I do have a question though in the interim. Y'all mentioned that you have been doing research on Oklahoma and Pennsylvania, and we've really appreciated that research. Could you talk a little bit about some of the lessons that you've learned, maybe if there were specific things that surprised you about the legal, social, and political context within those states?
I can start. As part of the research in Oklahoma, it included analyzing the 10th Circuit and which judges are sitting on the court. And surprisingly, the 10th Circuit has judges appointed by like 8 different presidents. I think there was still a sitting judge from President Carter. I mean, it was kind of wild. That's not usually how that happens. It's usually just the last 2 or 3 presidents that are represented for judge nominations, but there were judges from all over the spectrum, from many presidential nominations, including both Bushes. So I found that to be the most surprising about my Oklahoma research.
When looking into Pennsylvania, I mentioned very briefly in the presentation that it's like a politically divided state. They have, like some politicians who are much more progressive and some who are much more conservative. And like the control kind of seems to flip back and forth, which makes advocacy very interesting in that space. And I think like one of the most surprising things for me about Pennsylvania is first that they actually passed a law in 2022 that increased HIV criminalization. And second, that there's a lot of evidence that general criminal laws are used to prosecute people with HIV like more severely. So basically an example of that would be if someone is charged with assault, if they have HIV, that might be upgraded to aggravated assault rather than just like the lower level assault charge. And so even though Pennsylvania might have some fewer like HIV specific criminalization laws than some other states, they have a lot of general criminal laws that are still used to prosecute people with HIV more severely.
Thank you both. We had one more question that came through the chat. So with the current administration's ideology of operation and changes being made to the EEOC, do you foresee it being harder to pursue challenges?
I could take that one. I think like Dana and Kailey mentioned, again, excellent presentation. Thank you so much. The types of claims in the employment context may become harder because of the EEOC, and that was the question, EEOC needing to sort of do the pre-clearance and give the right to sue letter. But also, as Dana and Kailey mentioned, most states that we have done research in, which would be states that have HIV criminalization type statutes and perhaps less friendly environments overall to people living with HIV and disabilities, do have ADA type comparator statutes within their state law. And so pursuing litigation or protective lawsuits in your state or the state of where the harm has occurred would be a potential option. And I do want to note that moment of hope as we're coming to a close, that we have seen across the HIV and LGBTQ movements that state courts and utilizing state claims, whether they be in state courts or through human rights commissions or in federal courts as well, can result in very favorable outcomes for historically marginalized folks, because as with the ADA, non-discrimination protections at the federal level are generally a floor, and states can exceed those protective measures within their state laws and regulations.
Thank you, Kara.
That's a fantastic example of that right now, if you're looking for some hope.
I just wanted to ask anyone that's on the screen right now if you have any final thoughts or messages for our advocates as we close.
I guess I'll say, kind of going on the hope thing that Kara mentioned. I mean, even in this time, which is obviously very stressful and difficult, we've seen movement in the HIV decriminalization space in North Dakota and Maryland, like just this year. So, like, things are still happening, even if it might be more difficult to make it happen in some spaces.
Yeah, and I would ultimately say, like, for those new to this space, like, HIV decrim tends not to be like politically divisive. It's a good thing to do all around. And so hopefully that will continue to be the case, and we can continue to have pretty partisan agreement that HIV decrim is a worthwhile legislative effort.
And then we've put up a QR code as well if you want to join our PJP email list. I know Kailey and Dana mentioned getting involved in a coalition. I think now is really the time for us to do that foundational work and really focus on that. So please sign up for the listserv if you are interested in getting involved in the HIV decriminalization movement. I think it's really time for us to be creative, to think outside the box, and to really try and attack these laws with new and innovative and different strategies than what we've utilized in the past. And with that, I think we have come to the end of our webinar. I just wanted to extend a thank you to Northwestern, to Kara, Dana, and Kailey, for Dee, our comms manager behind the scenes, getting us all together on StreamYard. I think this has been such a wonderful topic. I know a lot of coalitions, and advocates have been asking about the ADA and how it intersects and works with HIV criminalization. So I really hope that we were able to provide some clarity for you all. And until next time, I hope you enjoy the rest of your week.